Does Ruth Bader Ginsburg have something to apologize for? There are some on the left who are angry at her for not retiring when President Obama was in office and the Senate was controlled by the Democrats so that her replacement could be another liberal. I'm going to tell you why I think they are wrong. We've already politicized the appointment process, and we're now trying to politicize the resignation process, even the death process. I'll explain why I think she did the right thing by remaining on the Supreme Court as long as she had the intellectual ability to serve. This is Alan Dershowitz, and you're listening to The Dersh Show. Amidst all the well-deserved praise for the late, great Justice Ruth Bader Ginsburg, after all, she will be the first woman in history to lie in repose in the Capitol, there is grumbling going on among people on the left. Mostly it's silent grumbling, but this morning's New York Times had an article by Emily Bazelon assessing why Ruth Bader Ginsburg didn't resign when there was a Democratic president and a Democratic-controlled Senate, so that she could be replaced by a liberal, perhaps a liberal woman, much like her. I think it's misplaced grumbling, and in the article in today's Times, Emily Bazelon focuses on personal issues. She argues quite correctly that Ruth Bader Ginsburg never let men tell her what to do during her entire lifetime. She was a woman determined to do it, to quote Frank Sinatra, her way. And she did it her way up to the moment of her death. But there's a more profound and more fundamental reason than her own personal wish to stay on the Supreme Court till age 87, coming close to breaking a record. Oliver Wendell Holmes was a few years older when he resigned and then died shortly thereafter. The institutional reasons, though, are quite important, and they're in an age where everything is partisan. These institutional reasons are not being given enough consideration. So let me raise them. The Supreme Court is politicized enough without us having justices timing their resignation so that their successor could be appointed by a president of their liking on their political side and confirmed by a Senate on their political side. Timing resignations only further politicizes the Supreme Court. The Constitution permits the timing of resignations, unlike the Pope, who historically serves until he dies, although a recent Pope did resign. Justices of the Supreme Court often do resign when they get older. Some resign shortly before they die. Some, like Justice O'Connor, resign years and years and years. Justice Souter, years and years and years, while they still have much life left in them. The Constitution leaves it to them. The Supreme Court appointment is a lifetime appointment. Technically not. Technically an appointment during good behavior, but that basically means it's up to the incumbent, unless he engages or she engages in some impeachable offense, which has rarely happened in our history. It's up to the justice to decide whether and when to retire. Justice Ginsburg decided not to retire. She was going to be carried out and finish her business until the good Lord took her away, which he did on the beginning of Rosh Hashanah, the beginning of the Jewish New Year. Quite ironically, according to Jewish tradition, if you die between the Jewish New Year and Yom Kippur, those are 10 days during which you can seek repentance. If you die during the period of time when you can seek repentance and long life, the tradition is you lived a just life. You lived the life of a tzaddik, a just and righteous person, and God didn't give you the need to repent because it was clear you had little to repent for. But according to liberals, according to some people on the left, Justice Ginsburg had something to repent for. If she had retired while President Obama was in office and while the Senate was still controlled by Democrats, she obviously would have been replaced by a young woman who would now serve probably an additional 20 or 30 years and follow in her footsteps and maintain, if not a 5-4 majority, depending how you count Chief Justice John Roberts, at least a 4-4 split with the Chief Justice casting the deciding vote. But no, she stayed on, and she stayed on at a time when her death would allow President Trump to make her appointment. According to her granddaughter, her dying wish was that she not be replaced by President Trump and the Republican Senate. President Trump has raised questions about whether that's accurate, but I certainly want to give credit and believe the dying wish of a great woman to her grandchild. And it's consistent, of course, with Ruth Bader Ginsburg's strong political views. She caused a storm in the Supreme Court when she attacked President Trump, something justices often do in private, but almost never do in public. But she did it in public, and it's clear, beyond dispute, that she did not want to be replaced by President Trump and a Republican Senate. But her wishes have no constitutional standing and no basis in the law. And so the question is, will she be replaced by President Trump? And that really depends at this point on 1 or 2 more senators. We already have 2 senators who've said they won't vote for a midnight appointment, a late appointment in the a race for the presidency. Mitt Romney, who might be a third, has indicated that he hasn't made up his mind and hasn't made an announcement, probably will make an announcement in the next few days. Lindsey Graham has announced that although back in 2016 he said the new precedent should be that no president should get to nominate and the Senate should not get to confirm a nominee in the year of the election, but he's now changed his mind, saying that because both the presidency and the Senate are controlled by Republicans, it's okay to nominate and confirm justice. And he said there are enough votes to do that. Interestingly enough, he said it before we know who the nominee is going to be. And it really does depend somewhat who the nominee is. If the nominee is somebody who is too extreme for an additional 1 or 2 Republicans, we might see a different dynamic at work. But I suspect the president will be smart enough to seek what the Constitution requires him to seek, not only the consent of the Senate, but the advice of the Senate. Remember, the words of the Constitution are advice and consent. And if he seeks the advice of the Senate before he seeks their consent, he'll know in advance whether his nominee might lose him 1 or 2 votes and almost certainly would not make that nomination. Although making a nomination, even one that loses, might help his electoral chances. The point, however, is that the Supreme Court is becoming so politicized. The appointment process is politicized. The confirmation process is politicized. People want to see the resignation process politicized. If that happens to an even greater extent than it's happened already, we risk seeing the Supreme Court turn from an institution that's supposed to be above politics and above partisanship into yet another popular branch of the government whose members are picked based on their ideology and whose terms are served based on their desire to have their ideology continue. It would be a great tragedy. It would not be the first time in American history this has happened. The New York Times and others have reported that no nomination in history has ever come so close to an election. That's simply factually inaccurate. The greatest Chief Justice in American history, John Marshall, was nominated to the Supreme Court in January of 1801, after the president who nominated him became a lame duck, and was confirmed by the Senate in late January, just months before the new president, Thomas Jefferson, was to assume office. Not only that, but on the eve of the transition between our second president, John Adams, and our third president, Thomas Jefferson, right on the eve of that transition, John Adams stayed up until midnight signing judicial statements of who was going to be appointed. These judges, many of them, were called the Midnight Judges. They were appointed by John Adams as his farewell gift to Thomas Jefferson. Adams, as you know, was a Federalist, representing a more conservative approach to governance. Jefferson was, in those days, called a Republican Democrat, representing what we would today call a more liberal approach, though it was complicated by slavery. The liberals were more from Virginia and more supportive of slavery, and the conservatives from New England and less supportive of slavery. So the liberal-conservative breakdown doesn't work perfectly, but in the day, back in the day, Jefferson and Adams were as different as, say, Obama and Hillary Clinton, or perhaps President Trump and Joe Biden. And so the decision by Adams to nominate a slew of Federalist judges and swear them in, he didn't make it. In fact, some of them were not sworn in until too late, which gave rise to the famous case of Marbury versus Madison. But enough of history. Let's talk about the present, and let's talk about the future. So now here's the reality. We have Ruth Bader Ginsburg. Tragically, she dies. Very much wanted to live till the end of the Trump administration's term, whenever that might be. I think if Trump had been reelected, she probably would have resigned. She probably realized she couldn't make it for 4 years, but obviously her preference would have been to live until she could be replaced by somebody of her choice. That didn't happen. There's an old Yiddish expression that says, man plans, God laughs. God makes these decisions, not man, and God made the decision to take Ruth Bader Ginsburg during the Trump administration. I'm sure there are people of a religious bent who will say, that was God's plan. But whosever plan it was, it works to the benefit of the Republicans. So now we have a vacancy. We have a vacancy that constitutionally can be filled by the incumbent president, whether he wins or loses the election. We have a Senate controlled 52 to 48 in favor of Republicans. That has the constitutional power to confirm, but it has in it many Republican senators who are on the record saying it is wrong as a matter of principle to confirm a nomination so late in the process. And they were talking about 8 months, 7 months, 6 months. We're now talking about weeks. So the issue is going to be one of whether or not Republicans can be made by voters to stick with their principled opposition to late-term appointments by a president who is up for re-election, or whether they will just engage in the same partisanship that they argue Democrats would engage in. In fact, Lindsey Graham today used my expression, an expression I've been using now for years. I first used it to describe the Bush versus Gore. I call it the shoe on the other foot test. Lindsey Graham today said that if the situation were reversed and the shoe were on the other foot, he used those words, if the shoe were on the other foot, the Democrats would be doing the same thing. I have absolutely no doubt that he is correct about that. I have absolutely no doubt that Democratic Minority Leader Chuck Schumer would be finding reasons and excuses for rushing a nomination through if the shoe were on the other foot. But just as two wrongs don't make a right, two hypocrisies don't make principle. And so as a great supporter of the United States Supreme Court, as someone who cares deeply about the Supreme Court as an institution, about its role in our system of checks and balances and separation of powers, about its historic role as trying to be above politics, as to its function to resolve disputes between the other branches of the government. I worry deeply about the future of the Supreme Court. Presidents now look to nominate the youngest possible justices so that they will remain on the Supreme Court for the longest possible time. Two of the women on President Trump's short list are one 46 years old, which means if she lives as long as Ruth Bader Ginsburg did, she could serve on the Supreme Court for 41 years. Another one on the list is 38 years old. 38 years old. Just 3 years older than the minimum eligibility to be president of the United States. That would mean she could serve for half a century on the United States Supreme Court. Some of our greatest justices, including Ruth Bader Ginsburg, were appointed later in life. Ruth Bader Ginsburg was, I think, 60 years old when she was appointed. Oliver Wendell Holmes was 60 years old when he was appointed. Justice Louis Brandeis, one of the greatest justices in history, was approximately the same age. A certain level of maturity and experience are required to serve on the United States Supreme Court. And I think it's a mistake to be picking people based on how young they are and how long they will serve. The criteria should be whether they would serve with great distinction on a court with such great history, not how many years will they serve. So I worry about the politicization of the Supreme Court. It's inevitable, and the Supreme Court will lose some of its stature as a great objective institution. It was Alexander Hamilton who in the Federalist said, the Supreme Court is the least dangerous branch because it is without purse and it is without sword. It depends for its authority on the belief in the American people that it is an institution worthy of respect. Recall what President Andrew Johnson said when the Supreme Court said that the rescission of treaties with Native Americans was unconstitutional. Andrew Jackson said, the Supreme Court rendered its decision, now let them enforce it. That's not the approach that should be taken. We should all support Supreme Court decisions. Al Gore, when he lost the election, in what he believed was an unfair 5-4 partisan decision, said he respected the Supreme Court and he would not contest the election. I'm afraid those days may be gone. I'm afraid today, if a president were to attack the Supreme Court as a partisan institution, there would be a lot of Americans who would support him or her and would look to how the Supreme Court has become partisan political. The blame goes back a long, long way. It's hard to know where to begin. Was it Roosevelt's court packing plan? Was it the decision to reject Judge Bork, which was highly politicized, or the confirmation battle over Clarence Thomas? Is it the current action by Republicans to rush through a nomination after they said they would not rush through a nomination done just months before the election? History will judge whose fault it is. I'm here to say that the result is not a good one for America. The result is dangerous. The Supreme Court is a necessary and important institution. Justice Ruth Bader Ginsburg served honorably on the Supreme Court for many years. I hope she is replaced by somebody who would serve as honorably on the Supreme Court. I don't think the process should be rushed. I don't think the process should be made partisan or political. And I hope that perhaps over time we will see depolitization. Now, the Democrats aren't helping this because some have argued if this happens, the Democrats should take revenge. If they win the presidency and take over the Senate, there have been arguments made by some that the Democrats should then pack the court, expand the number of justices from the current 9, which has been the rule for well over 100 years, to 11 or 13 or 15, and then have a Democrat president and a Democratic-controlled Senate nominate the additional 2, 4, 6 justices that would assure a Democratic majority on the Supreme Court for the long-term future. It's Chief Justice John Roberts who really wants to maintain the neutrality of the Supreme Court, who has argued over and over again there is no such thing as Republican justices or Democratic justices. There are no such things as Trump justices or Obama justices. I wish he were right. Bush versus Gore suggests that's an aspiration more than a reality, but it's becoming worse. We will now have Republican and Democratic justices picked because they're Republicans or Democrats. It would get worse if we packed the court. So those of you who agree with me that the most important thing is not who is on the court at any particular point in time, but whether the Supreme Court remains an institution, a neutral, apolitical institution whose judgments are worthy of respect, please join me in arguing for principle over politics, for a decision to keep the Supreme Court as nonpartisan as possible. It's a wish, it's a hope. I hope it will, over time, come true. In the meantime, the next few weeks will be filled with antagonistic political repercussions as the president, at the end of this week, nominates a justice, as the Republican-controlled Senate has hearings, whether or not the vote will take place before the election, as President Trump has asked, or after the election, perhaps during a lame duck period, depending on the outcome of the election, remains to be seen. Let's hope that the process remains a process that we as Americans can be proud of. On this day, I think our thoughts should go back to Ruth Bader Ginsburg. I think she did the right thing by staying on the Supreme Court for as long as she felt she had the intellectual capacity to do so. If I were writing the Constitution anew, I would write it differently. I would have either fixed terms for justices, say 25 years, or I would have a mandatory retirement age, perhaps 80, so that justices can't serve for half a century. In a democracy, there's a real question about whether anybody should serve for half a century. It's so interesting that many on the right who call for term limits on Congress, term limits on the Senate, don't want term limits on the United States Supreme Court, at least as long as their justices are serving on the Supreme Court. So on this day where Justice Ruth Bader Ginsburg will begin her journey to the Supreme Court, where she will lie in repose, and then the Capitol, where she will lie in repose, and then Arlington National Cemetery, where she will join her husband. My thoughts and my deep, deep admiration remain with the great Justice Ruth Bader Ginsburg. Now we're ready to hear your views, your questions, your comments. Let's begin with Sandra from Michigan.
Hello, Mr. Dershowitz. I just listened to your last podcast recording regarding replacing Ruth Ginsburg on the Supreme Court. I disagree with your conclusions. I'd like to ask you, what do you think the Democrats would do if they were in a similar situation? What do they think of the good of the country, or do they think of what's good for the Democrat Party? So just throwing that out there. I live in Ann Arbor, Michigan. Thank you for giving me the opportunity to express my opinion.
Well, thank you so much, Sandra. I agree with you 100%. I think the Democrats are as hypocritical as the Republicans. Both will put partisanship and party loyalty over what's good for the Supreme Court when it serves their interest to do so. The other day I talked about my grandma who came from Poland, and when I would come back and tell her the Brooklyn Dodgers won a game, she'd say, yeah, but was it good or bad for the Jews? That's what I think most Republicans and Democrats think today. Not is it good or bad for the Jews? Is it good or bad for our party? Is it good or bad for my reelection? Is it good or bad for my ideological interests? So two hypocrisies don't create principle, just like two rights don't make a wrong. So I'm critical of both sides, the Democrats and the Republicans, for introducing partisanship into the process by which justices of the Supreme Court are nominated and confirmed. Now let's hear from Ken from Texas.
Hi, Alan. My name is Ken McConnell from San Antonio, Texas. My question is this. I was wondering if you might be able to demystify a little bit of the First Amendment and the right to peacefully assemble. At what time does a peaceful assemblance no longer become a peaceful assembly? And also, in the day and age of COVID, do governments have a right to block off certain areas where people can protest so that they are kept safe from the rest of the public with regards to spreading of the disease, or even just have a place where they can peacefully assemble and not interfere with the day-to-day life of other people, period. Thanks. We appreciate the show. It's been great so far. Have a good day.
Thanks, Ken. I love San Antonio, the Alamo. What a great city, great old town. Thanks for your question. It's the hardest question of all. I was teaching at Harvard Law School for 50 years. That issue, the limits of the First Amendment, took up a lot of my time. I wrote a book called Shouting Fire, in which I criticized Oliver Wendell Holmes' notion that the test for free speech is you can't shout fire falsely in a crowded theater. There have been efforts to try to limit and indicate what the limits of the First Amendment are. None of them have completely succeeded. The right to peaceably assemble means peaceably to assemble. You can't loot. You can't engage in violence. You can't threaten people and incite people to hurt other people. There are also time and manner restrictions on free speech. You can't bust into a church and start screaming, God is dead, God is dead. There's a place for that. You can stand outside the church and say God is dead, but you can't disrupt church services with that. A very important case was decided by the Supreme Court a couple of years ago, where a horrible, horrible organization would go to the funerals of veterans who died in action, who were killed defending our country, and try to make a mockery of the funerals. And was that protected speech? Tragically, it was. Burning a flag. As Justice Brennan once said, if he ever saw somebody burning a flag, an American flag, he'd walk up to him and punch him in the mouth. But he upheld the right of Americans to burn flags. Your own flag. You can't burn somebody else's flag. And you can burn it on your property, not on somebody else's property. So there are all kinds of restrictions on free speech, but not on the content of free speech. If it's good enough for Martin Luther King, it's good enough for the Ku Klux Klan. If it's good enough for Elie Wiesel, it's good enough for anti-Semites and Nazis marching through Skokie. So you can't make distinctions based on the content of the speech, but you can limit speech based on externalities. Nobody has the right to go into your neighborhood at 3 in the morning with a loudspeaker and wake everybody up and tell them to vote for your candidate or to support a woman's right to choose or the right to life. You can do it at 10 o'clock in the morning, and there are decibel limits on how loud your loudspeaker can be. There can be crowd limits on how large the crowds can be. And yes, the government can restrict crowds during a COVID, but they have to do it fairly. They can't say, for example, that if you support Black Lives Matter, you can go to a protest, but if you support a woman's right to choose or the right to life or something else, no, you can't go to a protest for that. Also, there are limits. If you can control how many people can go into a church for prayer, could it be fewer than the people who go into Walmart to shop? These are all the kinds of questions that are coming up now in the face of the virus, and we'll see how the Supreme Court responds to them. Hey, Katrina, South Carolina, my wife's home state. Let's hear from you.
Hi, Professor. This is Katrina Otto, and I'm calling from South Carolina. I just recently moved here from Connecticut. I was a Connecticut native. I agree with what you said about the president certainly has the authority and the responsibility to fill an open seat for the Supreme Court, and I hope that he does move forward. I also think it's a novel idea and a good idea what you suggested about the future and no nominations after the conventions, because I think that might get the gangs a little under control. I'm not 100% sure of that, but what we see, the average person, is mob mentality and brutality and power struggles, and quite frankly, we're tired of it. So I thank you very much. It was a very interesting post that you did. I enjoy everything that you write.
Thank you so much. I wish I were in South Carolina. I used to go there all the time to visit my late mother and late father-in-law. A great, great, great state. Look, I think the reason for having a rule, whether it's a rule that says no nominations after the conventions or any other time, is you get a single rule that apply to both parties and avoid the situation we have now, where the Republicans stop the Democrats from making a nomination 8 months before an election. And then the Democrats were not able to, or are not able to, stop the Republicans from making a nomination just weeks before the election. You have to have a single rule, a single standard. It can't be left up to senators to decide what's best for their party, what's best for their ideology. That's why I'm in favor of rules that are binding on both parties equally. The content of the rule isn't as important as having a rule. So thank you for your great question. The next question is from Max in Alabama.
Hi, Alan. Big fan here. Max from Alabama. I'm wondering what the current state of your relationship with the distinguished professor Norman Finkelstein is after your very highly publicized argument and debate on Democracy Now! And the sort of back and forth you guys had over the substance of your book, The Case for Israel, etc. How's that going now, if it exists at all? Thanks.
Thanks, Max. It's an interesting question. As some of you may know, Finkelstein had argued that my book, The Case for Israel, which became a national bestseller and a university bestseller, has been translated into dozens of languages. He claimed that I didn't write the book, that the Mossad wrote the book, the Israeli intelligence agency wrote the book. Fortunately, I write everything by hand, and I have every word of mine written by hand. And as a result of his false allegations against me and other falsities in some of his books, he was denied tenure at DePaul University, and I was given credit or blame for it, depending on what side of the argument you're on. I simply alerted the university to what he had done and his false claims. They obviously made the decision. Ironically, about a year or so ago, my son and I were having dinner at an Indian restaurant in my neighborhood, and who walked in but Norman Finkelstein, and he sits at a table just a few feet away from me, and my son didn't recognize him, but I did. And when we finished dinner, I walked over and sat next to him and said, Norman, can we talk? And we started having a decent, reasonable conversation about our differences, and then it became heated. And as soon as my son Elon realized who it was I was talking to, initially he didn't realize who it was, he walked out in a huff. He said, I'm not going to sit at the same table with a man who has so insulted my father and lied about him. But we had about a 15-minute conversation. It turns out he taped it. He recorded the conversation surreptitiously without me knowing it, and he put it on his website. So I think you can probably hear our conversation. And I didn't consent to the conversation being recorded, but I don't have any problems. I said what I said, and I believe what I believe. I don't think Norman Finkelstein is a scholar. I think he's an ideologue who writes in extreme ways. I fundamentally disagree with his views on Israel and the Middle East. He's compared Israel to Nazi Germany, you name it. But I believe in freedom of speech. So he has the right to go all over the world and make his arguments, and I have the right to respond to him. And I don't think we're going to be meeting anymore in Indian restaurants, but we will continue to have our dialogue. Hey, Frank from New York, what do you have to say?
I disagree with your contention that the conventions should be the cutoff date for justices to be appointed. If you apply this standard, what precedent will you be setting? Will this affectionately deem the presidency a lame duck office before, or particularly in the midterm election, effectually deeming the presidency a lame duck? Particularly in the midterm, where he or she could run for re-election. Where do you think the Washington political ilk would push this issue to its outermost limits? Would this deem any president ineffectual as commander-in-chief after their political party's convention? And Justice Ginsburg had plenty of opportunities to retire before her horrible rectal and pancreatic cancer diagnosis, but she opted to push the issue until a woman president was elected. But President Trump's victory over Hillary Clinton, this carefully crafted plan blew up in her face. The sitting president has the right And some would contend that he has the obligation to appoint a Supreme Court justice when they are in office. Thank you very much.
I appreciate your argument. It's a particularly valid one constitutionally, but would you apply it as well to Democratic presidents? Did you make that argument? Would you make that argument when President Obama nominated Merrick Garland 8 months before the end of his term? This issue wouldn't have come up at all. Nobody would have disputed the power of the president to make an appointment on the eve of the election had the Republicans not thwarted the Democratic president's nomination of Merrick Garland. They were the ones who created the rules of engagement. And under their rules of engagement, this nomination should not go through. If they hadn't done that, there'd be no issue because, as I've mentioned previously on the Durr Show, President Adams nominated not only Chief Justice John Marshall, but a slew of other judges on the eve of his departure as president. So it was the Republicans who created this issue in 2016. And to be consistent, you have to argue that the Republicans were wrong in thwarting the Democrats in 2016 if you are to argue that they are right today in rushing through a nomination before the election. Hey, Nick from Seattle, I hope the fires are not burning anymore, and I hope the smoke is not as bad as it was. What do you have to say?
With regard to RBG and the open seat in the Supreme Court, I am not really confident in either party. Both seem to have been extremely hypocritical about filling a justice seat during the election year. The Republicans seem to be doing the opposite thing that they did in 2016, and the Democrats are doing the opposite thing that they did. I know Obama had pleaded with the Senate in 2016 to pass or to start the nomination process of Merrick Garland, and now he's kind of changed his tune, and so have most of the mainstream Democrats. Lindsey Graham had said that he did not want a person added to the Supreme Court during Trump's final year. He seems to have backtracked. So in summary, I think both parties are extremely hypocritical and are just being pragmatic about filling the court. Thanks.
I think you're 100% right. There's no question at all that there is hypocrisy on both sides. What we need is a single standard. If the Republicans were right in 2016, they should apply that same standard today. If they're right today, they shouldn't have applied a different standard back in 2016. But we live in an age where everything is partisan. Everything is political. Everything is it good for my party? Is it good for my ideology? Too few people today ask, is it good for America? On this show, you're going to always hear principled arguments. What's good for America? What's good for principles? What's good for the rule of law? So thank you all very much for tuning in. This is The Durr Show, and as I promised, you'll never be bored. Call our listener line at 216-710-0050. I want to hear your questions, your comments, your criticisms, and your opinions. Remember, all calls are recorded, and we reserve the right to use your questions and comments on the air. Once again, the listener line is 216-710-0050. I look forward to hearing from you. The Durr Show is available on iTunes, Spotify, or wherever else you get your podcasts.